So we will go ahead and get started. Thank you everyone for joining us for our webinar on the International Entrepreneur Parole Rule. My name is Dustin Saldarriaga and I am an associate at Scott Legal PC. As I mentioned, today we'll be discussing an exciting new program that was announced earlier this year, the International Entrepreneur Parole Program, which we call IEP. We'll talk about what this program is, how you can qualify and apply for it, and what it might mean for you as someone who wants to develop your business in the United States. The IEP program fits very closely with our firm's focus on investor and business visas. And one of the topics we'll discuss is how someone, excuse me, how someone might choose between IEP and other investor visas, such as the E2 and the EB5 visa. A few things before we get started. This webinar is part of a series that we'll continue by doing at least 2 webinars a month on different topics. We already have a number of webinars scheduled and we'll regularly be adding more. At the end of this webinar, we will be sending you all a few things. First, we'll send the PowerPoint that we use in this presentation. We'll also send a link where you can sign up for the additional and upcoming webinars. And since this webinar is being recorded, we will send a link to the recording. We'll also send you a link to our YouTube channel where we'll be putting this video, and if you visit us on our YouTube channel, you'll see we have a number of our other prior webinars up there, as well as shorter videos, and these are on a range of immigration topics. So we invite you to visit our YouTube channel as well. A few housekeeping items before we get started. We do plan to reserve a few minutes at the end for questions. We invite you to submit questions through 2 methods. You can either use the chat box on the Zoom application, or you can use the question and answer box on the application. I'll be reviewing those and responding to them as the topic is touched in the presentation. Again, my name is Dustin, and I will be the moderator and a co-presenter for this webinar, along with the founder of our firm, Ian Scott. Ian has a vast amount of experience processing visas for people who want to grow their business in the United States. In fact, this firm was founded on an E2 investor visa 8 years ago. So to kick everything off, Ian, what is International Entrepreneur Parole, and what is this program we're talking about today?
Great, thank you very much, Dustin. And this program, it's definitely an interesting one, and that it's a program that was initially started way back during the Obama administration, and it's a program with what that administration recognized is that there, although there were some investor visas that were available to people, they were limited, and in some cases they required significant investment, and in other cases the investor visa was limited by your country of nationality. So before the international entrepreneur parole program started, there were really 2 common investor visas, and one was an E2 visa. As Dustin mentioned, our firm was founded on an E2 visa, and this particular visa requires that you invest a certain amount, what they call a substantial amount in the US. That amount is going to depend on the type of business that you're going to start, but it could be as low as $50,000, $60,000, $70,000 that you invest that would be enough to get you an E2 visa. But the one thing with an E2 visa is that it is only available to nationals of certain countries. So there are about 80 countries on the list. So that, and 2 of the countries that are not on the list are India and China, the 2 most populated countries. They're actually not on the list. So the E2 had kind of limited availability for many nationals. And the other big investor visa that was available is the EB-5 visa. And for entrepreneurs, this was a visa that typically required you to invest, $1 million under the old regime, and under the new regime, $1.8 million. So and you had to personally invest it. So it's not money that you could raise from angel fund or venture capital funds, and et cetera. You had to personally invest that money. So that put this particular investor visa out of the reach of most people as well. Now, in terms of the E2 and the EB-5 visas, there are other webinars that we've done that focus on these particular two types of visas, but we just want to touch base on them here for comparison purposes to the International Entrepreneur Parole Program. So during the Obama administration, as I said, they noticed that there was this deficiency, and they wanted to create another program that really could attract people, entrepreneurs who wanted to come into the United States. So we see some tech startups like Facebook, or some of the ones that are newer and are still in the infancy stages, like Uber and different companies like that have attracted a vast amount of capital and have created a vast amount of jobs in the United States. So this particular program was geared towards individuals or companies that had that entrepreneurial desire, and trying to create an ability for them to start businesses in the US, because ultimately when there is a business in the US, the US government feels that that business is going to have an economic benefit. If you look at a company like Facebook, for example, and you look at the number of jobs that that particular company has created, that certainly answers the question of whether there is some economic benefit. So what happened with this program is, although it was started during the Obama administration, it was paused during the next administration. So during up until now, I believe there's only been, this may have changed recently, but I believe there's only been one approved international entrepreneur parole case, and because the next administration chose not to, they didn't eliminate the program, but they chose not to pursue it, and as a result, there were few applications, or any applications that were made really weren't adjudicated. So there's only been one example of this particular program where there's actually been an approval. But when the Biden administration came into power, they kick-started this particular program. And now what you'd expect to see is a number of people applying for the program, because the government now does sponsor the program and will actually adjudicate the actual immigration benefit. So one of the things to kind of, and you'll hear as we go through the presentation that, sometimes we'll use the term visa benefit or visa, but this particular program, it actually is not a visa. When we think of a visa is a document that a consulate issues. So when you get an E2 visa, they put the E2 visa in your passport, and then you use that visa to enter the country. Now, this particular benefit, it actually is not a visa. And what it is instead is it's a status when you enter the U.S. called parole status. Now, parole sounds, it sounds like it's something bad, but in the immigration context, parole is an actual benefit. It's an immigration benefit. And what it allows you to do is to enter the United States for a period of time to develop the business. So when we talk about this particular immigration benefit and filing an application for this particular immigration benefit, it is for parole status. In terms of, and Dustin's going to go into the details in a bit, but in terms of, this is a program that allows you to ultimately, if it's worked correctly, to stay in the U.S. for 5 years. It's going to initially be granted for a 30-month period, but then you do have the option to renew. And we're going to go through the renewal process in a bit more detail. But in order to apply for the initial 30-month period, there are requirements that you have to meet. And then after that 30-month period, if you want to apply for a renewal, there are requirements that you have to meet. And those requirements are slightly different than the initial requirements to meet the initial 30-month period. But as I said, we'll go through those in a lot more detail. And then you look at, this particular immigration benefit. Children and spouse can accompany, and we're gonna go into some of the difficulties associated with that, with respect to applying for travel authorization, and the spouse is also able to apply for work authorization while they're here. And and we talked already about the differences between the E2 and the EB5. And as we go through the requirements, we may touch on more of these, more of these differences. For example, this particular visa doesn't require personal investment from the entrepreneur, whereas the E2 visa and the EB5 visa do. They're actually investing. But as we go through and we kind of think of any other differences between the E2 and EB5 program, we'll certainly point them out. The other, before that, just kind of one reason, because when we look at, very generally speaking, when we look at the E2 program, and let's say that someone was eligible for the E2, let's say that they met the requirements of the E2 investor program, it's probably a better immigration benefit, right? It's that particular visa benefit, you can renew it indefinitely. That particular immigration benefit, the issues surrounding entering the country and what you have to do to travel, it's definitely easier. But that particular immigration benefit, the E2 visa, does require that the individual owns at least 50% of the company. So it could be that somebody that's on an E2 visa actually transitions to this international entrepreneur program just based on the reduction in their ownership. So there can be at sometimes an interplay between these different types of visas. That is, that someone can be eligible for all three, and then they're going to be making the decision with respect to which one they apply for. And then if they do apply for one, it could be that their situation changes such that the person has to move to another visa. So this particular visa or immigration benefit does provide for kind of more options, even in the situation where one is immediately eligible for an E2 visa. So we talked, we talked a little bit already about, kind of what parole, what parole is. Just in terms of, nothing is certain in this world, but this particular program is probably a little bit more discretionary than most. Most immigration benefits that exist, they are a function of congressional law, where the law is kind of written into the statute, and the E2 visa, for example, it's based on an international treaty between the U.S. and a number of different countries, and then that has been formalized by Congress into law. This particular program, I think that what was happening during the Obama administration was that with the initial push for immigration reform, and Congress, not really that keen on acting to make any meaningful changes, the administration tried to implement, because they do have discretion to create these parole programs, tried to implement something that it's almost like a stopgap, or something that could temporarily assist entrepreneurs with respect to starting businesses in the U.S. And then finally, this is kind of you see this a lot with immigration benefits, is that this particular parole program is kind of not subject to judicial review. So to the extent that, for example, somebody decides to they're denied, and they say, well, I want to appeal this. They can't kind of appeal it and go before a judge. Where other certain benefits, like for example, if someone is applying for an EB-5 visa, a green card, then, and they're denied, and they feel that the denial was unjust, they could certainly sue the federal government in federal court, and kind of complain or try and obtain some remedy with respect to that particular denial. So.
Great, thank you, Ian. So let's talk a little bit about the requirements for this program. And so it's, as Ian mentioned, so there's a specific period of time during which you can get international entrepreneur parole. There's an initial period and then a renewal period. The initial period is for 30 months. You apply for that. If you are approved, you would be paroled into the United States for 30 months. And at the end of that period, you can apply for reparole, which would give you an additional 30 months. So the maximum period of time you can have parole under this program is 5 years or 60 months. So to get in, and the requirements for the two, whether it's initial parole or reparole, are slightly different, and we'll talk about that. So let's talk about initial parole. To receive initial parole, the applicant must fundamentally show that they and their business will provide, quote, a significant public benefit to the US, and they must show that the business has substantial potential for rapid growth and job creation. So really all the evidence that's being provided in this application is really supposed to be targeted at satisfying that requirement. There are three main criteria. The first is ownership. So the entrepreneur must own at least 10% of the startup business and have a central and active role in it. And what that last part means is that you can't be a passive investor here, such as you could be, for example, in an EB-5 visa, where you've just invested money in a project and you've basically done your job if you've invested the funds. Here, you actually need to be actively involved in directing and developing the business. And again, that is a 10% ownership stake for initial parole. And as we'll talk about, that's different for reparole, but initial application, you have to own 10%. The startup business actually needs to be a startup. That's the second big, threshold requirement. And what a startup is defined as is it must have been established in the United States, so it needs to be a US business, within the past 5 years before the benefit is applied for. It can be an LLC, can be a corporation, really any legal business entity. So the government's flexible on that. The final and third big requirement is what I think of as the funding or the financial requirement. And before I get into this, I'll note there is an alternative. So if this sounds, incredibly burdensome, keep in mind that the government does provide an alternative to this last requirement, and we'll talk about that. But ideally, what the applicant would be able to show to satisfy this third financial requirement is that the business has received investments of at least $264,147 from qualified US investors. And what the government has in mind here is kind of venture capital funds, some of the big ones that you might have heard of, like Sequoia. That really is what the government has in mind. These are typically seasoned investors who invest in a number of businesses. Important to note, this cannot just be a family member who's invested in the business, cannot just be the entrepreneur. The government really uses this investment piece as kind of part of the vetting process to say that, well, if a venture capital fund that does this as their business has vetted this entrepreneur and their startup and has decided they're worth funding, well, then the government will take that and say, okay, it's good enough for us for this piece. And that's what the government's doing here. In the alternative, the business can have received government funding. The minimum required amount there is $105,659. These numbers might seem unusually specific. The reason is that they are pegged to inflation, and they actually go up to this amount tomorrow, which is the start of the fiscal year for the government. So you might have heard a slightly lower number. That number is ending today, and you'll have these slightly higher amounts starting tomorrow. And there are, like I mentioned before, there are specific requirements for who qualifies as a qualifying investor. Um, for example, the investing fund, such as the venture capital fund, needs to be owned and controlled by US citizens or green card holders. And there are several other requirements to make sure that they are, like I said before, actually, an established, say, venture capital fund or another entity that invests regularly. One interesting note, the funds that are invested do not necessarily need to come from US citizens. It's just that the venture capital fund itself needs to be owned, majority owned by US citizens or green card holders. Now, I mentioned before there is an alternative. So let's talk about that alternative. And again, those first two requirements, the ownership as well as the startup, there is no negotiating those. Those have to be satisfied. What can be negotiated is this final financial piece. And the alternative is that if you cannot satisfy that piece, applicants who only partially satisfied this funding criteria can nonetheless receive parole by providing additional evidence of the startup entity's substantial potential for rapid growth and job creation. Now, this is really, the government provides examples of evidence that can be provided to satisfy this, but that's not an exclusive list. And the government's pretty clear that if you have other evidence that's not listed here, that really does show that this is a business with a lot of promise in terms of its impact and its ability to hire workers, that evidence can be and should be submitted. But some of the examples that the government has made clear that they will consider are documents, for example, that show that the entrepreneur has a unique educational background, unique achievements, academic achievements, a unique ability to advance the startup. Perhaps it's a serial entrepreneur. Perhaps there's been a lot of publicity around the startup. Prior experience operating a business and creating jobs. Perhaps this is the last bullet, but perhaps the entrepreneur or the business has patents that have been awarded to it. The government's very interested in knowing about those. If the business has been accepted to any reputable startup accelerators, that's very important to note as well. Corporate or tax records, any records that show that this is a business that has a track record of generating revenue, a track record of employing workers, all that is really critical information for the government to know. And again, in this, an attorney would help you kind of brainstorm how to advocate for yourself and for the business, and to really present yourself and the business as strongly as you possibly can in this application. One of the ways to do that is to think about who might write letters of support that would be included in the application to show the government that, government officials or, leading executives in your field or professors who know a lot about your potentially a patent you have or a technology that your business is putting forward. If those individuals are willing to write a letter, that absolutely can be included in this application. So think broadly. If you can't satisfy that financial component we talked about, it's time to really think broadly about, what evidence can we get that really shows the government this is a special business with a lot of promise, that it's going to grow rapidly and it's going to create jobs for people. So let's talk a bit about the specific pieces of evidence that can be included. And I touched on this before, but really, evidence, these four, headlining bullets here are kind of the main categories of evidence, or the main things you have to kind of satisfy for the government. And below that, I have specific examples of evidence. But again, this is not an exclusive list. So if what you have or what you think you can get is not on here, you should still move forward with getting that. So evidence that the entrepreneur has a central and active role. You can show specific academic degrees that they have. A resume would be a minimal requirement, but showing that they have experience in other businesses, actually running those businesses. Again, if there are letters from government agencies, qualified investors, or business associations that show that this entrepreneur is someone who is really a leader in their field, that's really valuable. Press coverage. is important. Participation in a startup, awards of patents. These are all things that can be included. Evidence that the entrepreneur has a 10% ownership share. This is pretty straightforward. So for this, you would want to show corporate documentation, such as share certificates. If it's an LLC, you may show an operating agreement. Potentially articles of incorporation might reflect the ownership stake. Tax records oftentimes will show the ownership stake. You'd want to include evidence like that to really show the government, that they shouldn't just take your word for it. They will need evidence, of any of these statements that you make, such as I own 10%. These are, the standard documents you can use to show that. Evidence that the investment funds are from a qualified investor. So if you do have a qualified investor, there's a good chance that they will already have these documents, because typically qualified investors, that is, a term that's used by the SEC, the Securities and Exchange Commission, a US federal agency. These organizations and companies that do this work typically have this documentation, they maintain it. So, this one, you would probably work closely with them to get the documents that would show the government that the fund, the venture capital fund, for example, that has invested in your business, actually is a qualified investor according to the requirements. But one of the things that would need to be shown, for example, is evidence that the fund has invested in other businesses, has made other past significant investments. This could be bank records, purchase agreements, tax and payroll records, things like this. And finally, evidence that the investment amount is substantial. So this would be evidence to show that your business has actually received the funds that you're saying it has received. So this can be grant or award letters, your company's bank statements showing the receipt of funds. You can show evidence that shows the trail of those funds, very similar to, say, an E2 visa or an EB5 visa application. And finally, if applicable, documents that show that the capital was used to purchase equity or other security in your business. So that could be, specific contracts that you may have with this investment fund. So what is the application process? How do you actually apply for international entrepreneur parole? Step one is for the entrepreneur to file Form I-941. If you have done anything involving US immigration, you know that you have to file a form. For whatever benefit you want, there's a form to get you that benefit. The form to get international entrepreneur parole is Form I-941. You may also know that the government publishes typically very detailed instructions for every form, pretty much every form that it accepts. That's no different for the Form I-941. So if you want to learn a little bit more or a lot more about this program, get really into the details of, for example, the evidence that the government will accept, or, what is a qualifying investor? The instructions for the Form I-941, which you can find by Googling them, have a lot of really helpful detail. The filing fee for this form is $1,200. And there is an $85 additional biometrics fee, which is where you give your fingerprints and your biometric information to the government. After the Form I-941 has been approved, as I mentioned, the entrepreneur must submit their biometrics, and this would happen either at a US consulate or at a USCIS field office near the applicant's country. And the final step is that once the biometrics have been submitted to the government, the applicant must visit the US consulate abroad, and that's where they would actually receive the boarding foil, which, as Ian mentioned, for the E2 visa, you actually get a paper in your passport. A boarding foil is a document that basically tells the government that you've essentially been approved for parole. You've submitted the I-941, that's been approved. At that point, you would then go to the border, the port of entry, to the border, to an airport, and present your boarding foil. And at that point, the immigration officer would decide, and they do at this point, even if you've been approved, they have discretion to decide whether you should receive parole and be able to enter the United States. I almost said be admitted into the United States, but there's a legal legal, meaning behind admitted. And as Ian mentioned, what's unique about parole is essentially that the government is allowing you to physically be in the United States for the purpose of developing your business. But the government, and we're not going to go into too much detail here because it really is a legal nuance that has a big immigration effect, but the government is not technically admitting someone who has parole into the United States. They are being allowed to be physically present for a specific purpose. And again, I know that's nuanced, but that is important to keep in mind. Again, this is not a visa. This is parole. But if the border officer, approves their being able to enter, then the person would enter and be able to develop their business at that point while having parole. For Canadian citizens, they are allowed the luxury of not having to go to a consulate. Once their form I-941 is approved, they can go to, say, the border or to the airport with their approved form I-941 and be admitted without actually first going to a consulate. A very common question that comes up is, can I submit the form I-941 in the United States? I'm already here. Do I have to leave and submit the form? The answer is no. You can submit the form I-941 from within the United States. It can be approved from within the United States. The problem is that you cannot get parole if you're already in the United States. So once your I-941 is approved, you would then have to leave, go to a consulate abroad, get that boarding foil, and then come back into the United States with parole. So you cannot be granted parole while you're in the United States. This is not parole in place. You actually need to physically leave the country and come back in and be granted parole. Now, family members. So, as Ian mentioned, there is a lot of discretion really with any immigration benefit, but especially so with parole and with the International Entrepreneur Parole Program. That's no different for family members. So essentially what the government says is that family members of the entrepreneur can can receive parole to join their family member. They would essentially submit what's called a Form I-131. The Form I-131 is an application for a travel document. And essentially they can submit that form either at the same time as the Form I-941 that the entrepreneur would submit, or they can submit the Form I-131 after. They have the option. But the family member would need to wait until that Form I-131 is approved. Then the family member would need to go to the consulate, get the same process, get the boarding foil, and come into the US with parole to join the family member. Important to note, once the family member is in the United States, they can apply for work authorization. The spouse can apply for work authorization. And to do that, it's really not much different from many other visas. When they're physically present in the US, they would file a Form I-765 and receive their work authorization if and when that application is approved. An important note that isn't talked about a lot, but one of the conditions of maintaining parole is that the entrepreneur must maintain a household income that is greater than 400% of the federal poverty line. The federal poverty line is quite low. So 400% right now, 400% of the federal poverty line for a household of one is $51,000. $51,520. For a household of two is $69,680, and this is all on the PowerPoint. For a household of three is $87,840. So 400% of the federal poverty line does get into a substantially higher amount as your household increases in size. So do keep that in mind. And for renewal, we can quickly touch on this just because it mirrors the initial parole application. So again, initial parole is 30 months, renewal is for an additional 30 months. You would apply for it at the end of your initial parole period. the requirements really do mirror the requirements for initial parole with a few slight differences. For re-parole, the business must continue to operate. Obviously, if the business ends, you're no longer eligible for parole. Also importantly, the ownership share is different. If you recall, initial parole requires 10% ownership of the business. The entrepreneur must own at least 10%. To apply for re-parole, only 5% ownership is required. To maintain initial parole, the entrepreneur's ownership share cannot drop below 5%. So basically, when you apply for initial parole, you need 10%. You have to maintain at least 5% through the initial parole period of 30 months. And then when you apply for re-parole, you need at least 5%. Once you get re-parole, that additional 30-month period, your ownership share can decrease more, but you always have to maintain some ownership share. So it cannot drop to zero. As long as it's above zero, you're fine in the re-parole period. And finally, during the initial parole period, the business must have either created at least 5 full-time jobs with the startup business, received at least $528,293 in qualifying investments, government grants, or awards, or a combination of those, or generated at least $528,293 in US revenue and averaged 20% annual growth during the initial parole period. So as with initial parole, this final number 3 here, there is an alternative criteria to satisfy it. If you have not created 5 full-time jobs or received that $528,000 in funding or generated that amount in revenue, you can submit evidence of the startup entity's substantial potential for rapid growth and job creation. And again, that's the same as for initial parole. So you can go back to that list we showed before where we get into the specific evidence, awards of patents, letters from government agencies, business associations, experts in the field, participation in startup accelerators, good publicity, things like this. That's what you'd want to show if you can't satisfy that third and final prong. So Ian, I'll go ahead and pass it off to you for the common
Excellent.
questions.
No, perfect. No, thank you very much. Thank you very much, Dustin. A lot of really interesting information there. So, let's send some of these questions, recap some of the things that that Dustin went through. But the first question, just in terms of what percentage of the business must the entrepreneur own? So that's going to depend on whether or not we're looking at the initial application or whether we are looking at the renewal of the application. So if we're looking at the initial application, we see that the entrepreneur has to own 10% of the business, and that they can't drop below 5% during that period. And similarly, in contrast, rather, for the renewal program, the entrepreneur has to own 5% of the business, and their percentage can't drop to zero. So that's definitely a lot less than what the entrepreneur has to own for an E2 visa, right? So definitely something that someone that was on an E2 visa could perhaps look. Let's say they attracted funding from another company, and this happens where someone is looking for a visa option, and the visa option unfortunately doesn't exist, right? So they venture capital, someone has an E2, venture capital buys, they drop well below their 50%. And then unfortunately, the person's no longer eligible for an E2, but it could be that the person now is eligible for this particular program and is able to at least stay in the US for longer, right? Because if you're here for longer, then maybe you can look at some other program in order to move to a different visa type. So the next question is, does the entrepreneur need to personally invest? And the clear answer to this is no, they don't. They don't have to invest anything, not 1 cent of their own money. So, again, that's very different from the E2 investor visa and the EB5. The EB5 is very strict that the individual is the one who has to invest. And the E2, the individual has to invest, but it's a little bit more flexible because the individual can invest either personally or can invest through another enterprise. So, but for this particular program, it's not required that someone personally invest. And that sometimes is a problem for E2, where an individual, has a great business idea, and but they are not personally investing any money, and it makes them ineligible for the E2 investor visa. So, yeah, so that's this is definitely another option for them to give them some type of an immigration benefit. The next question, how many people can really receive parole status for one startup? So there is a limit here, and it's 3. So, often when you have a startup, it's not just one person. Normally, there are a number of people who might initially come up with a business idea, or there are a number of people who have at least 10% ownership in the endeavor. And then the question of if all of these people are outside of the US, how many of them can come to the US based on this particular program? And there is a limit of 3. When you look at an E2 visa, normally it can be a maximum of 2 investors. They're kind of, generally speaking, it can be a maximum of 2 investors. But the E2 visa does allow for E2 employees then to join the company if they're the same nationality as the E2 investors, and that number is, can be unlimited. There's no kind of upper ceiling, whereas for this particular immigration benefit, there is a maximum amount of entrepreneurs that can get this benefit for one company. So the next question is really an interesting one, because it's one I think that when they design this program, and I think it's a function of the fact that the person's coming under a status called parole, and there are well-established rules for parole status. And the question is, can the person travel? And the answer is an unusual no. That they can't just enter the US under parole status and then just leave. They actually have to enter under parole status and then apply for travel authorization, and that travel authorization can take some time. It can take 5 to 7 months. Sometimes if you just file for the travel authorization, that can be quicker than, because a lot of the time we see people for other immigration benefits applying for work authorization and travel authorization at the same time, and those usually take closer to the 5 to 7 month mark. If they're just applying for travel authorization, sometimes we see those applications come back faster, and in this case the person only has to apply for travel authorization, at least the entrepreneur. If it's the spouse is going to apply for both travel authorization and work authorization. But yeah, it's an interesting part of this particular program that there's this extra hurdle that you have to go through if you did in fact want to travel immediately after entering the US. So does the international entrepreneur rule lead to a green card? So the answer is no, it doesn't. And there aren't really any immigration benefits, non-immigrant visas, that lead to a green card. The way that the green card system works in the US is that there are a number of different green card categories, and you would look at those green card categories and you would see if you're eligible for one of them, and then you can apply. But the system, other countries have systems where they're points-based systems, where the country might look at a number of different factors to ascertain whether or not the person has accumulated enough points to get permanent residency. But here it is, you look at the individual benefit, and for all of the green card categories, there aren't any green card categories that give you the option of obtaining there aren't any green card categories where you can utilize your current immigration status to as some type of benefit or requirement for obtaining the green card. So this is similar to if someone has an E2, that doesn't lead to a green card. If someone has an F1, a B1, an L1, none of those visas lead to a green card. It's just that if you have them, you can apply for a green card if you're eligible for one. And then the last question is, can an entrepreneur adjust or change status in the US? For example, could they adjust status to EB2 national interest waiver? So this is, this would be one of these options where an individual, comes here, they, let's say they, have an endeavor that's in the national interest, and they, there's a whole webinar on national interest waiver. It's one of the options for moving to a green card. But let's say that they meet all the criteria for a national interest waiver and they want to apply for the green card. Then the question is, can they adjust status? So the adjusting status is a mechanism for someone who's in the United States where they can file green card paperwork and receive the benefit and receive other benefits while they're in the United States. But unfortunately, when someone's in parole status, they're still able to apply for a green card, but they're not able to adjust status. So if they did want to do the national interest waiver, they would have to, apply for the green card at the consulate. So we would do the USCIS processing for the national interest waiver, where we would file the documentation. We would file the I-140 with the supporting documentation for the national interest waiver. But then the individual would have to, apply at the consulate for the actual green card. So it's, parole status actually doesn't permit you to, parole status doesn't permit you to adjust status or change status in the US. Perfect. And I think that was it for questions.
That's right. Yeah, we actually did cover all of the questions that that came in. So let me see if I can stop sharing this. Well, anyway, so in order to not hold us up with my technological inabilities, I do want to thank you, Ian, for taking the time to speak with us. And I want to thank all of the individuals who participated in today's webinar. As I mentioned before, we will be following up with an email that has both a link to this PowerPoint, a link to our YouTube channel where we'll post this video, as well as we have a range of other webinars there, as I mentioned before. So please do check that out. And a link to sign up for our future webinars, where we touch on a range of other immigration topics and visa options. So again, thank you all for taking the time to join us. We hope this was helpful, and we do hope to see you on a future webinar.